Now, Brigadier is a very senior ranking officer in the South African Police Services, and not only senior but well decorated. I think that should be put on record as well. Well decorated. You were very aware that that which you call an official engagement with the accused had to be done, accused number 2, had to be done in terms of the law, not so?
Yes, and it was done in terms of the law, my lord.
Thank you. And you just mentioned that you explained to him his entitlements in terms of Section 35 of the Constitution. I don't want to get there because you have already testified about that in the trial, within the trial. So,
yes, it is so, my lord. That's correct.
Now, in the first engagement, before you could get into the offices to verify his alibi, if you so remember, what was his choice with regard to his rights to legal representation?
There wasn't, my lord. I explained. There was no desire for the legal representative, be it private or at the state expense, and there was no reasons or desire from him to remain silent. He said, "I would be willing to talk to you open and freely," and he did. Hence, he gave me the explanation of saying he was at work on the date in question, my lord.
You know, all jokes aside, this really got me emotional. This got me emotional because let's talk about it. The warning statement, just in case some of you are not aware, when you're stopped by the police, they have to say to you, because the Constitution of South Africa requires that any arrested person be informed of their right to remain silent and the consequences of not remaining silent, their right to choose and consult with a legal practitioner, and their right to have a legal practitioner assigned to the detained person by the state and at the state's expense if substantial injustice would result. Okay, the South African Police Service rules prescribe that arrested people be given the form, 14A, Notice of Rights in terms of the Constitution, which describes these and other rights of the arrested person. We don't hear the brigadier saying that he gave him this form, but let's continue. And according to Section 35 of the Constitution of 1966, arrested, detained, and accused persons, very important, guys, if you are stopped by a police, you don't have to be arrested. You can be detained or accused, but they must say these things to you. And we've seen it over and over again in the movies. And this is what got me emotional, that, so if everyone who is arrested for allegedly committing an offense has the right to remain silent, okay? And in the movies, they say something like, you have the right to remain silent. Anything you say or do will be used against you in a court of law, blah, 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 blah. You have the right to an attorney or an advocate. In this case, you have the right to an advocate. And if you can't afford one will be appointed for you. Let me know. Type a 1 in the comment section if you've watched movies where they say this over and over again. So now applying it to this Bongani Ntanzi arrest, incarceration, detainment, English bundle depleted there, okay? Bongani Ntanzi's detainment. He was detained because he hadn't seen a magistrate yet, remember? And you have 48 hours. Everybody is entitled 48 hours to go in front of a magistrate where your charges are read to you. And, if you're not a person like Baloyi, loud, outspoken individual, fully informed on your rights, you won't know this. Are police intimidating? Yes. Listen, if I'm stopped, even if I haven't done anything, police are intimidating. Period. Okay. If I am stopped while driving, I'm gonna let you know. It is absolutely intimidating for me. Okay. But imagine Bongani Ntanzi, guys, and let's apply it to what the brigadier is saying here. He's saying he read him his rights, and Bongani Ntanzi said, I don't need no legal representation, okay? I'm Nkabi from Nongoma, and I'm good to go. I will represent myself. What question do you have? I'm going to answer it right here and now over here in the Carltonville. Because what do you mean at the Senzo Meyiwa trial? I want to talk freely and fairly. This is what the brigadier is saying. And take a look at Bongani Ntanzi. Take a look at Bongani Ntanzi. Does this man look like he said this to the brigadier? Does it look like his rights were read to him? Does it look like he understood his constitutional rights at that moment? Don't forget, this is on the 18th. So he's been incarcerated, detained for over 48 hours. I'm not saying he was tortured or anything. Let's go with that everything was done freely and fairly. But I'm just asking you, would he have known his constitutional rights? Would he have known he had a right to a legal representation? Would he have known he had the right to remain silent? Oh, this really broke my heart. I'm not going to lie. But while we're talking of the Constitution of South Africa, I also want to add as well that every accused person has a right to a fair trial, which includes the right not to be compelled to give self-incriminating evidence. Let me end it right here, and let's continue listening on. This is going to be a tough one to give my commentary on, but each job, we continue on.
Thank you. In respect of the second engagement, after having been to his employer to go and verify his alibi, what was, if you explained his rights, what was his rights with regard to legal representation?
There was still no view, my lord, and there was no desire or wish by the accused for the legal representative. And when we dealt with the issue of the identikit, and as I've placed it on record, he said it's not him. That was in relation to the response of saying he does not need the legal representative. He's still willing to speak open and freely. And when that question was put of the identikit, it was defeated by him to say it's a question of mistaken identity.
So, would I understand you to mean, would I understand your answer then to mean that you had explained all his rights to legal representation, you gave him options and choices, he understood them, and he decided to waive his right to legal representation and said, no, I don't want a private attorney, I don't have an attorney on my own, I don't want an attorney or a legal representative that I can be assisted with by the state. I am prepared to continue speaking for myself or on behalf of myself as I am engaging with you. Do I understand you to mean that?
You understand me correctly, my lord.
Thank you.
He waived his rights, man.
Thank you, Brigadier. Now, you would agree with me, South Africa is a constitutional democracy country that is founded on the ethos of the Constitution. In other words, is the Constitution up there, and there are these little legislations which should be tied up with the Constitution, not so?
Yes, I totally agree, my lord.
Below those legislations, there are directives, there are ordinances, there are policies, etc., 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 but which must also comply with the spirit of the Constitution, not so?
Yes, yes, my lord, that is correct.
Thank you, Maras. Thank you, Brigadier. Do you understand, Brigadier, that a brigadier is a person who holds who's a commissioned officer and also holds the rank of being a peace officer?
I do understand, my lord.
And in a peace officer, it's somebody that is equivalent to a magistrate. Are you aware of that?
My understanding, justice of the peace is equivalent to a magistrate.
Excuse
Justice
me?
of the peace. My understanding, I understand the peace officer different. I thought the magistrate in terms of is equivalent to a commission officer in the sense of being justice of the peace. That's my understanding.
No, I think my semantic there nearly threw me under the bus. You know, I wanted to say justice of the peace, not a peace officer. You know, a peace officer can be a traffic cop. You know?
Indeed.
Then he stops there and then he asks us our licenses. You understand? Yeah, that's a peace officer. But the justice of the peace is at the more elevated level.
Yes, I do agree with that assertion, my lord.
Thank you. Now I am going to request to refer to Exhibit XX.
What?
Exhibit XX. That's the thing, you know, for so many documents. And they get to be so voluminous, it just gets to be very tedious and heavy for us to carry them every day here to court. But Exhibit XX. Exhibit XX, my lord.
What is that?
Yes, XX is that document that says an interview with regard to a suspect. An interview regarding an interview with a suspect. Mr. Ramusipili is trying to correct me, but it's a statement regarding interview with a suspect. That is Exhibit XX. We might not necessarily go to Exhibit XX if there's a document that is similar to Exhibit XX, which is a statement regarding interview with a suspect. I think it will also suffice. I'm not so sure if my colleagues have got any, just to speed up the process. I would be utilizing mine, but I'm going to need it as we engage in this process.
I do have a similar document. I suppose it's a warning statement. That's what you're referring to. In the front page says statement regarding interview with suspect.
Yes.
Yes, I have one, my lord.
Or it is affectionately known as a warning statement.
Yes, if we are referring to the same document. Yes.
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 In front it has got that South African Police Service insignia.
Correct. That's the one. I think we have the same document.
And do you have any knowledge who designed this insignia?
I beg your pardon?
Do you have any knowledge who designed this insignia?
No.
You don't know?
I know.
I do.
Exactly.
I know who designed it.
Okay, I think we'll have a lecture with it one day. We'll talk
Thank you.
about it. Yeah.
Thank you. I'm waiting for my colleagues, my lord, to be to follow as we go along in respect of this exhibit. I see Mr. Baloyi is still trying to page through. I'm not so sure whether we can proceed as is paging through or we need to give it indulgence to get to this document.
So, what are we waiting for?
Oh, no, it's fine. Man. I was just
My
trying
colleagues,
to...
I'm sure they know that document. Is that normal? You don't know that document? Mr. Ramsepi?
Yes.
So everybody knows that document?
Yes, it was sent up by Advocate Michel.
Yeah, it talks about in the presence of a police officer, station commander, blah, 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 blah.
It's in the role of the prosecutors.
That's it, yeah.
Thank you.
Okay.
Now, Brigadier,
Yes, my lord.
we've got a face of the document. Yeah, unfortunately, the one that I have is not numbered. On the first page, it also only starts to be numbered somewhere on page number 3. But nonetheless, I think that would not be a train smash. Now, when you open that document, the very first paragraph there
Yes.
says South African Police Service instructions statement regarding interview with a suspect. Do you see that?
I do see it, my lord.
And then paragraph number 1, it says completion of this statement. Do you see that?
Completion of statement.
Yes.
Yes, that's what I see, my lord. Correct.
Yes. Now, what does paragraph A read? What does it say? Do you mind to read it into record?
No, I don't mind, my lord. It
Please.
reads as follows. The station commander must consult with the prosecutor on circumstances in which the prosecutor requires that a warning statement of a suspect be obtained. Second sentence, in every such case, the suspect must be interviewed and his statement must be completed. This statement must be completed every time the suspect is interviewed, irrespective of whether the suspect has been arrested or not.
Thank you. Thank you. Now, when you page over, there's also an insignia there. Letters written South African Police Service. Again, a statement regarding interview with the suspect that are written in both letters. Do you see that?
I do see it, my lord.
Thank you. And below that, there is that paragraph that consists of 3 sentences. Do you mind to read that into record?
I don't mind, my lord. It reads as follows. The form must be completed every time a suspect is questioned, irrespective of whether the suspect is in detention after an arrest or not, where any space provided on the form is sufficient. Continue on a folio and attach the folio to that page. Folios must be signed by the suspect, interpreter, deponent, and commissioner of oath.
Thank you, sir. Now, this statement must be completed every time the suspect is interviewed, irrespective of whether the suspect has been arrested or not. It's not me who says this, it is this document. Do you follow?
I follow, but
Thank you.
No, but I'm not done, my lord, in answering. I follow the first part. I follow, but you cannot ignore subsection A of point number 1, which says very specific, my lord. The station commander must consult with the prosecutor on circumstances in which the prosecutor requires that a warning statement of a suspect obtained. Now, a warning statement, my lord, can either be obtained when a person is arrested, or a directive can come from the prosecutor to say, before we make a decision, go and obtain the warning statement. So this directive is very clear. So you cannot ignore section A, which says there must be consultation. It's a different view when police are conducting their own investigation, stopping a person, giving the person his right, and then things follows. There's no time to consult with the prosecutor, so this does not apply.
So you're basically saying, let me put it this way, what you have just said now, it's an exception to what the law says.
No, that's not what I'm saying, my lord. I'm saying let's look at this form, because I'm directed to what this form says in terms of the instructions. The form, the first paragraph, indicates clearly that there is a communication between the prosecutor and the police. Then the prosecutor gives instruction to the police to say, go and obtain a warning statement. The prosecutor, the only way the prosecutor can get a communication of what that person has said, indeed it must be documented in terms of a warning statement. It's a different story in my situation, my lord, when I was interacting with accused number 2. There was no directive from Advocate Baloyi or any of the advocates to say, go and get a warning statement. So I'm saying this does not apply in circumstances like that, my lord.
From my understanding, not that I don't know what you're talking about, what is that document?
It's what we will term...
No. What is it? You told me about... Has
warning
it got a
statement.
heading?
Yes.
What is the heading?
Statement regarding interview with suspects. It's a warning statement, my lord. That's the term we use.
Thank you. Now, may you please reread the second paragraph that I've referred to you, that is on the following page.
The second paragraph the one that starts by saying the form must be completed every time a suspect is questioned, irrespective of whether the suspect is in detention after an arrest or not. Where any space provided on the form is insufficient, continue on a folio and attach that folio to that page. Folios must be signed by the suspect, interpreter, deponent, and commissioner of courts.
Thank you. Thank you. This form must be completed every time a suspect is questioned, irrespective of whether the suspect is in detention after an arrest or not.
That is correct, my lord.
Thank
but
you.
No, yes, that's correct, my lord. But I need to explain. I need to qualify this. This portion that Advocate MNISI is making me read, it's actually page number 3, starting from the beginning. The first paragraph, the written sentence or instruction, states clearly that there must be a directive between the prosecutor and the police. Then what is reading, it's a further instruction that goes down. In other words, my lord, you can't read this in isolation, because I seem to be getting an impression as if this is a standalone instruction that I was made to read now. It's not. First, there is a directive coming from the NPA to the police. We are then being told what you must do. So you can't ignore the part that in my situation, there was no directive by the prosecutor to say, go and obtain a warning statement. There was no such. It was simply a police investigation. And my lord, I can also say, this happens all the time. Police officers arrive at the scene of a robbery or murder, interviews people, give chase to suspects, and arrest them. There's no form that they will sit down and say, let us write now what is being said. These forms, you normally find them at the detention cells when a person is being prepared for appearances in court, or in instances when it is clear that directive will be taken and the prosecutor says, go and obtain a warning statement before we make a decision so that we can hear what the person says. It's a different situation when it came to what I did with accused number 2, man.
Let me break up the tension between MNISI and the Brigadier and the Funda Temba, who keeps having to read that paragraph, which MNISI has held on tight to the words must be completed every time. And I said it in my previous video with the English language. It's very clear. Once you use the word must, it means there is no other option. There is no there is no exception. Oh gosh, English bundles. There is no exception. And guess what? It must be done. But the Brigadier says, no, not at all. That isn't a fair assertion by MNISI. There's an exception. You know, we could be dealing with burglars. I'm a policeman. And, you know, we don't have time to go look for the prosecutor. We're out here doing police investigation. Now, you're the very person who said this was a prosecutor directive-led investigation, and you had to consult with the prosecutor with regards to Ukeli Khumalo. You could not get that warrant of arrest on your own accord, and they did not approve of you moving forward. So what was the difference here? Kelly Khumalo doesn't get to move forward, but Bongani Ntanzi, not only did you not consult the prosecutor, but you independently continued your investigation with no directives from the prosecutor. I am confused. Which is which, Brigadier? Which is which? You're confusing me. Was it a prosecutorial-led investigation or a police investigation? Which is it? Can we clarify in the comment section down below? But let's continue on.
So the essence of what I'm saying, my lord, we cannot read this form in isolation of the instruction that is very clear, which is the first sentence. That instruction is coming from the NPA and the interaction is to the police to go and obtain a warning statement. And that is where it says, even if it's 2, 3, 10 times, 20 times, in those instances, you must have it recorded. Whether the person is arrested or he's not arrested, as long as there's that directive, then you must complete this form. In my situation, my lord, again, without repeating myself, there was no such directive.
Thank you, Brigadier. Brigadier, do you agree that this document was designed for the police, to be used by the police, and not for the National Prosecuting Authority of South Africa?
It was designed as a guideline, my lord. There is no, I think we dealt with this part during the trial within trial. there are many warning statement forms, my lord, and not necessarily like this. Others don't even have what is contained here. It's simply a guideline. But on this specific one, my lord, I'm dealing with it as it's been put to me, because the form itself, it's not me. I'm being directed to this form to comment on what it says. And I'm saying the first sentence of these forms clearly indicates that there must be a communication between the prosecution and the police. Then the steps then must be followed as per this form. So you can't ignore the part of the prosecution and the police because the form was not designed by the police. That's what the form says. That's what I'm being directed to comment on, my lord.
Brigadier Gininda, you have just read the second paragraph, which says, which is just an emphasis of what is supposed to be done when a police officer engages a suspect. And it says, this form must be completed every time a suspect is questioned, irrespective of whether the suspect is in detention after an arrest or not.
Yes, but my lord,
This is
sorry, Mr. Minister. I thought you were done. My apologies.
this is law. Unless you're creating your own little law in your own little corner there. But this is South African law, as it is contained in this form.
Yes, sir.
The state doesn't want to interfere with Advocate Mrs. Cross-examination, but the witnesses said ad nauseam that the operative part is that first sentence that says there must be a consultation between the station commissioner and the prosecutor. Whatever follows must be read subject to that operative part.
Yeah. Anyway, yes, Mr. Minister.
Excuse me, madam.
No, you can continue.
Brigadier,
Yes, my lord.
would you agree with me? Now we are going to do a standard 3 analysis. Would you agree with me that there are cases where the intervention of a prosecutor would not be necessary? For instance, in a case where, actually, let me not get there. Would you agree with me that there are cases where the intervention of a prosecutor would not be necessary and the police must just investigate that case from beginning to the end on its own and table it before a prosecutor? Such cases do exist, not so?
So,
Yes.
during the investigation process, I suppose, is that what you meant? During the
Yes.
investigation process?
Yes.
Yes. But under
Thank
the
you.
guidance of obviously the supervisor who will guide the relevant member, and then, but the ultimate decision maker is the NPA. So that docket at one time or another will sit at the office of the NPA, and they may be of the view that, look, we are not happy with what we have. Go and do 1, 2, 3 further, which has
Thank you.
happened on this matter. We spoke about it, Madam. So the ultimate arbiter in these proceedings is actually the NPA. Whether you involve them at the beginning or you decide not to involve them, but at the end of the day, you will never get to court without sitting down with the NPA, Madam.
That is what is called instructions that a prosecutor will give for further investigations, not so?
That is correct, my lord.
Thank you. That will be an instance where the police have started with the investigation, they've made the arrest, they've brought the accused before court. He has already appeared at court. The prosecutor enrolls the case at court. He goes through it and realizes that we still need to get this and this and this and this and this information as part of further investigation. Do you follow?
I follow, but it's not the only instances, my lord. Even if the matter is not enrolled.
I'm talking about that instance. I'm talking about that instance, not yours. I'm talking about that instance.
Yeah,
Let's concentrate on that instance, Mr. Gininda.
okay, which instance then? Let me understand.
The
Because
one
I
that
thought
I've
the
just
question was
cast out now. The police receives a complaint. It goes out, investigates the complaint. He found that there are merits in the complaint which warrant the arrest of the perpetrator. He goes on and arrests the perpetrator. He brings him before court, and then he takes the docket to the prosecutor. The prosecutor enrolls the matter. The suspect appears at court. After appearance, prosecutor postpones the case. After postponing the case, the prosecutor takes the docket into his office, sits down and gives the investigating officer instructions. That is the situation that I'm talking about. Let's
Yes.
concentrate on that one.
Well, yes, in that example that you're giving me, yes,
Yes.
that's how the prosecutor will give instructions.
Yes. Thank you. In that particular instance, don't you use this document, Exhibit XX,
No,
when you have an interview with the suspect?
my lord. So,
Yes.
and I want to move with the example that has been given.
I am asking a simple question. In that instance, interview with the suspect.
My lord. So,
Yes.
and I want to move with the example that has been given.
I am asking a simple question. In that instance, don't you use a document which is called a statement regarding an interview with the suspect? This document, don't you use it?
My lord, I can hear Mr. MNISI very loud and clear without raising his voice. It's just mind it, because
I'm
I'm
not raising
answering.
my voice. This is
Well,
how I speak.
it sounds like that to me, because I'm going to answer you.
Okay.
I was given a broad example of how this particular example started. From the time of the arrest to the time it's taken to the prosecution, a person appears and instructions then are given by the prosecutor. I cannot now be expected to answer only one portion. I want to answer it broadly. So, because I feel now I've been confined to only focus on one thing. I was given a broader picture, and I want to deal with that broader picture in terms of the answer, my lord.
Okay,
And
you
I'm
can
saying,
explain, Mr. Gininda, can explain.
it's not an explanation, it's an answer, my lord. The question has
Answer
been
it.
put to me.
Yes.
Now, my lord, in that example that I was given, when the person appears, before the person appears, a warning form statement would have been completed. You cannot appear before the warning statement is taken. So that will be the first step in preparation, in processing that person to appear before court. So that warning statement, I want to deal with it because the question relates to the warning statement. The first part would have been completed. Secondly, the person then the docket gets taken now to the prosecution. This is the example that I was given. The prosecution, based on the evidence and explanation given to it contained on the docket, the NPA will make a decision then to enroll the matter. In that instance, my lord, if there are outstanding investigation, as Advocate MNISI is saying, then further instructions will be given to the IO to follow. I'm not sure whether the question is to say the further instruction is that further warning statement must be taken, because at that stage, a warning statement is already taken. You cannot appear before the warning statement is taken. So if the assertion is that after the person has appeared, there is further instructions to take a further warning statement, it's an unusual practice, me as a policeman, that I've heard. It's a different story when the person has not appeared. So that's how I can answer it, man.
I think the struggle that Gininda is having here, and I can see Ramasipili's play, okay? Don't forget, Advocate MNISI is a 2-in-1, okay? He has prosecutor experience. He has been on the other side of the courtroom. So he can be both left and right. So he knows what needs to be done on this side, and he knows what needs to be done on the left-hand side. And he knows what the policeman must come with him. Must come with. Wow, English today. He knows what the policeman, okay, the mere policeman, just a police officer, this one. But this one is a decorated police officer, okay? He knows exactly what he needs to bring. That's why he is hammering down on this point. That's why he has him reading it over and over and over again. And that's why Brigadier Gininda is struggling to argue with MNISI. And in that battle of the giants, he then moves to, there's no need for you to shout. Sir, you're deflecting, because rewind, okay? He definitely didn't shout. That was MNISI's voice. Actually, there were other moments where he was shouting, and you let it go, Brigadier Gininda. So don't pull that fast one on us. We are watching you. All eyes on you, sir. Shame on you. But this is a long video. I'm going to stop it here. You already know part 2 of this back and forth is coming up. Thanks for watching. Catch you on my next upload.